Court records are meant to show how justice is delivered, but not every decision is spoken aloud. Some cases are shaped in delays, side conversations, and silences the record cannot capture. These are those cases. This is what happened before the gavel fell.
The courtroom opens late, not because anyone is missing, because no one is in a hurry. The benches are half full. They always are at this hour. People waiting for answers. People waiting to be told what happens next. The clerk calls the case. Daniel Reyes. The name echoes once, then disappears into the room. Daniel stands. He has learned the timing. Not too fast. Not slow enough to draw attention. Neutral, careful, practiced. His attorney rises beside him and opens a file that no longer needs opening. The corners are soft. The tabs are worn. The pages inside have been handled more than they've been read. This file has learned patience. The defense requests a continuance. The request is clean, short, confident, no emotion, no urgency. It sounds less like a request and more like a reminder. The prosecution does not object. They never do. The judge lowers their eyes to the file. Not to read it, not to study it. Just long enough to remind the room that the case exists. Granted. The word lands softly. No gavel. There rarely is. A new date is set, 3 months out. No explanation for the date, no discussion of urgency. Daniel exhales. Not relief. Recognition. The notice said this hearing mattered. The envelope was official. The language was firm. The last notice said the same thing. Movement was promised. Resolution was implied. But movement doesn't always mean forward. Sometimes it just means away. Outside the courtroom, the hallway moves. Other cases are called. Plea deals entered. Charges dismissed. Sentences announced. Names are spoken with finality. People leave changed. Daniel stays exactly the same. A clerk types one word into the docket. Continued. Nothing else. No explanation. No commentary. Later someone will read this record and see restraint. They'll see balance. They'll see professionalism. They won't see what didn't happen. Weeks pass. Daniel fills out forms, job applications, housing paperwork, loan documents. There's always the same question. Do you have any pending charges? There is no box for yes, but nothing is happening. So he checks yes. The case follows him quietly. The next hearing begins the same way. Same courtroom, same bench, same fluorescent hum overhead. Different date. The defense asks again. This time a reason is offered. Ongoing discussions. The phrase lands softly, vague enough to protect everyone. No names mentioned, no details offered. The prosecution does not object. The judge pauses longer this time. Granted. 6 more weeks. Still no gavel. Daniel asks his attorney what this means. The answer is careful. It's not bad, he's told. It just takes time. Daniel asks how much time. The attorney doesn't answer that part. The third continuance comes from the prosecution. The defense does not object. The symmetry is clean. On paper, it looks fair. Everyone agrees. Everyone cooperates. No one pushes. The record reflects balance. No one appears harmed, at least not officially. In chambers, the door closes. What's said there is not recorded. It never is. No transcript, no audio, no memory that can be reviewed. When they return, the next date is pushed further out. Daniel watches the calendar change. He doesn't react. He's learned not to. Months pass. A witness moves out of state. Another stops returning calls. Evidence sits. Memories dull. Urgency erodes quietly. Nothing improper happens. No rules are broken. That's the most unsettling part. The fourth continuance doesn't require a motion. The court schedules it on its own. Administrative. Efficient. The clerk enters it without looking up. Daniel receives the notice in the mail. Same language. Different date. The case is still open, still pending, but no one is preparing for trial. No subpoenas issued, no motions filed, no urgency remains. The system has found a place for it. Not resolved, not dismissed, stored. Daniel stops telling people about the case. Not because it's over, because explaining it feels pointless. There's no update to give, no answer to offer. Just time passing without direction. The case doesn't move forward. It doesn't fall apart. It waits, and Daniel waits with it. A year passes. Then another. The docket doesn't change, but Daniel does. He checks it less often. He stops expecting movement. The case hasn't gone away. It's just learned how to stay quiet. When the case finally appears on the calendar again, it's for a status conference. 5 minutes scheduled. The judge asks one question. Are the parties ready to proceed? The defense asks for more time. The prosecution agrees. The judge nods. Continued. Indefinitely. No verdict, no dismissal, no explanation, just a decision not to decide. Someday, someone will search this docket. They'll see a case that never concluded. They'll assume it was forgotten. They'll be wrong. This outcome required agreement, repetition, silence. It required everyone to benefit just enough from delay that no one stopped it. The last entry on the record is clean. No opinion, no commentary, just a date, and the word that replaced judgment. Continued.